In this lecture, we would like to discuss the draft Arbitration and Conciliation Amendment Bill of 2024. So, in this regard, we would like to discuss the very attempt of the government over the last decade. India has taken significant steps to strengthen its arbitration law to help establish itself as a global law for international arbitration and to provide greater certainty to investors regarding enforcement of contracts. The latest round of proposed amendments to India's arbitration law aims to streamline the arbitration process, reduce avenues for court intervention, and increase the efficiency of arbitration. So, building on the momentum from the amendments to the Act of 1996 in 2015 and 2019 and 2021, the Indian government has proposed a new round of changes to Indian Arbitration and Conciliation Act 1996. The very draft Arbitration and Conciliation Amendment Bill 2024 seeks to promote institutional arbitration, further reduce court intervention, and facilitate the timely conclusion of arbitration proceedings in India. The 2024 draft bill comes into the Parliament in February 2024, and among the first objective of the amendment is that promoting institutional arbitration in India. While the 2019 amendments to the Arbitration Act envision the setting of an autonomous body known as the Arbitration Council of India for the promotion of institutional arbitration in India. The 2024 draft bill aims to provide a new fillip to institutional arbitration with the following key changes. So, the very definition of arbitrational institution under the draft bill, as it was defined in the draft bill as a body or organization that provides for conduct of arbitration proceedings under it, as is by an arbitral tribunal as per its own rules of procedure or as otherwise agreed by the parties. This definition is preferable to the approach adopted in the 2019 amendments, which required an institution to be designated by the Supreme Court of India or a High Court for it to be considered an arbitral institution. So also another amendment into this very draft bill is enhancement of powers of arbitral institution. Arbitral institutions are proposed to have enhanced powers, including power to extend the time limit to issue an award, to order a reduction of arbitrators' fees where delay stems from arbitral tribunal, and to substitute arbitrators. And the very amendment is in regards to section 29 by making a new provision under section 29A. These powers currently vest exclusively with the courts. This proposal would also ease some of the burden upon courts to address applications and seeking extension of mandate for an arbitral tribunal, and so also in regards to the first institutional nature of arbitration. Another amendment aimed at elimination of grading of arbitral institutions. Under the 2019 amendments, the Arbitration Council of India was envisaged to have the responsibility for grading arbitral institutions and framing policies in this regard. The 2024 draft bill, while retaining the Arbitration Council of India duty to promote institutional arbitration and strengthen arbitral institutions, as provided in a new section, section 43D, proposes to replace the grading power of the Arbitration Council of India with functions such as recognition of arbitral institutions and providing model rules, procedures, or guidelines, among others. And as regarding the second amendment relating to the Act is in regards to interim measures of protection by court as provided under section 9 of the Arbitration and Conciliation Act of 1996. The draft bill proposes to modify the scope of section 9 by restricting parties from approaching the court for interim measures during arbitration proceedings. This is intended to encourage reliance on arbitral tribunals for interim relief instead of courts, thereby reinforcing the autonomy and efficiency of arbitration and reducing pendency before courts. However, this proposed amendment may become controversial since the availability of interim measures from courts at any stage of the arbitration proceeding constitutes critical support for such proceedings. Such relief is necessary to protect the subject matter of the arbitration in many situations, such as against third parties over whom the arbitral tribunal cannot exercise jurisdiction, or where the arbitral tribunal is non-functional. Section 9, as it stands, provides the right balance by permitting parties to approach courts for interim relief. In this situation, further, once the arbiter tribunal is constituted, as Section 9, subsection 3 mandates courts to not entertain an application for interim measures unless the remedy provided under Section 17, which deals with interim measures by the arbitral tribunal, is not efficacious. Courts have further limited the availability of relief after the arbitral tribunal is constituted by directing parties to approach the arbitral tribunal as long as the courts have not applied their mind to the pending applications. And it was decided in 2022 by the Supreme Court in the leading case ArcelorMittal Nippon Steel India Limited versus Ishar Buck Terminal Limited to reduce pendency of Section 9 applications before courts. The expert committee had suggested inserting the new provision permitting courts to grant limited interim relief to enable parties to approach the arbitral tribunal for interim measures of protection. The expert committee's suggestion on amending Section 9 reflect a more balanced approach than the restrictive amendments in the draft bill. And as regarding that, the new section in the draft bill, Section 9A, is regarding emergency arbitration. The draft bill proposes the insertion of a new section 9A specifically designed for emergency arbitration. Section 9A, subsection 3 allows an emergency award to be enforced in the same manner as if it were an order of an arbitral tribunal under Section 17, subsection 2 of the Act. The proposed Section 9A addresses the absence of express provisions in the Act on emergency arbitration. This lack of express legislative sanction had until recently made the status of an emergency arbitrator and the enforceability of their awards a point of contention. So, in that context, we would like to discuss the decision of the Supreme Court in 2022 in the leading case Amazon.com and the investment holdings LLC versus Future Retail Limited and others. The Supreme Court held that an emergency award in an Indian seated arbitration is enforceable in the same manner as an interim order of an arbitral tribunal under Section 17, subsection 2 of the Act. However, Amazon did not deal with emergency awards passed in foreign seated arbitrations. Such awards could only be enforced by filing an application under Section 9 on the basis of emergency award. This workaround is as so difficult as it requires parties to petition the courts anew for relief that has already been granted by the emergency arbitrator. The absence of direct enforceability for foreign-seated emergency awards limits the efficacy of emergency reliefs. The draft bill now tackles this issue by amending the provision to Section 2, subsection 2, to extend Section 9A to foreign-seated arbitrations, thus permitting their enforcement in the same manner as emergency awards in India-seated arbitrations. So, also, the very amendments also in regards to promoting efficiency. So, for that introduction of time limits for dealing with certain applications. In the 2024 draft bill also introduced various time limits aimed at improving the efficiency of India-seated arbitration proceedings. So, in case of that, we would like to discuss the first one, the 60-day time limit for disposing of applications under Section 8. The 2024 draft bill proposes a time limit of 60 days within which courts must dispose of a party's application for referral to arbitration where there is an arbitration agreement as per Section 8 of the Arbitration Act. For this proposal to work in practice, it would have to be supplemented by other measures aimed at reducing the pendency of arbitral applications before Indian courts. And the second feature in regards to time limit is 30-day limit for an arbitral tribunal to dispose of jurisdictional objections as preliminary issue. So Section 16 of the Arbitration Act embodies the well-known principle that an arbitral tribunal is empowered to rule on its own jurisdiction. The 2024 draft bill proposes to streamline and increase the efficiency of arbitral proceedings by introducing a time limit of 30 days within which an arbitral tribunal must dispose of any jurisdictional objection as a preliminary issue. The proposal also requires the arbitral tribunal to record the reasons for deferring a ruling on the jurisdictional objection should it not rule in the manner envisaged in this draft amendment in writing. And so also in regards to time limits, another feature of the draft bill is that 60-day time limit for appeals under Section 37, subsection 1 of the Arbitration Act of 1996 lists that the limited set of orders where a party is allowed an appeal against an order issued by a first instance court as part of its supervisory jurisdiction over an arbitration. These are an order refusing to refer the parties to arbitration where a valid arbitration agreement is alleged to exist as under Section 8 of the Arbitration Act, or an order refusing to appoint an arbitrator where the parties are failed to make such appointment, or the parties agreed upon procedure has not led to such appointment as provided under Section 11 of the Arbitration Act of 1996, and also an order granting or refusing to grant an interim measure as provided under Section 9 of the Arbitration Act of 1996, or an order setting aside or refusing to set aside an arbitral order award under Section 34 of the Arbitration Act. The 2024 draft bill proposes to introduce a strict time limit of 60 days for such an appeal, which will run from the date when an appealable order is received by the aggrieved party. So, in that regard, also by reducing court intervention or application for interim measures, the very draft amendment in regards to interim measures provided speeding up the process of commencing arbitration proceedings, availability of interim relief through emergency arbitrators, and also in that connection we have discussed some important leading cases already in our lecture, just that we have finished. So, in regard to that, we would like to discuss another important feature, and that is in relation to the very appointment of arbitrators. And in the very draft bill, and it is referring to Section 11 of the Arbitration and Conciliation Act. So, in 2017, a high-level committee recommended that appointments of arbitrators under Section 11 be done by arbitral institutions graded by the Arbitration Council of India instead of the Supreme Court or High Courts. These recommendations found their way into the Act through the 2019 amendments, but the amended provisions were never brought into effect. Yet the draft bill proposes more changes to Section 11 aimed at enlarging the role of the Arbitration Council of India. The draft bill adds a new provision at several places in Section 11 requiring the party seeking appointment of an arbitrator to disclose the number and details of arbitration proceedings between it and the counterparty, and any award passed. While the rationale behind the requirement this requirement is not explicitly stated. It seems intended to address concerns related to arbitral bias. However, the disclosure contemplated appears to be severely limited and would likely be ineffective. The draft bill also proposes the deletion of Schedule 4, which is model schedule of fees. Instead, the council would determine the fees of the arbitral tribunal in ad hoc arbitrations where parties have not agreed on fees. While the idea that the fees should not be fixed by statute, which is difficult to amend, is laudable, there is no guidance provided on how the council is supposed to fix the fees. The proposed amendments stop short of addressing the big ticket issue, the unilateral appointment of arbitrators. The expert committee had suggested several changes to Section 11 to deal with unilateral appointments clauses, but these have inexplicably not found their way into the draft bill. A constitution bench of the Supreme Court has currently reserved its judgment on the validity of such appointment clauses. It is important to clarify that arbitration agreements providing for unilateral appointments remain valid and enforceable with the appointment procedure under Section 11 being followed for arbitrator appointments. And another important change that would be made under the Draft Arbitration and Conciliation Amendment Bill of 2024 is regarding Section 20, which deals with place of arbitration. So, the very draft bill provides two proposed amendment option to Section 20, which refers to the place of arbitration. In option 1, the expression place of arbitration in Section 20 is replaced with sit in subsection 1 and 2 and venue in subsection 3. This is a welcome change which resolves the ambiguity in the statute. Option 2, on the other hand, wholly recast Section 20 and mandates that in domestic arbitrations other than international commercial arbitration, the seat of arbitration shall be the place where the contract or arbitration agreement is executed or where the cause of action has arisen. And option 2 also completely takes away parties' ability to choose the seat of arbitration, militating against the principle of party autonomy. Parties may choose a seat different from the jurisdiction where the contract was executed or the cause of action arose. And this is well recognized in the post judgment by the Supreme Court. in the important landmark judgment in regards to this is Indus Mobile Distribution Private Limited versus Data Wind Innovations Private Limited, which was decided by the Supreme Court in 2017. Option 2 also takes away the ability of two Indian companies to choose a foreign seat which they may prefer due to factors such as risks of delay and or broader intervention by Indian courts. Thus, it nullifies the Supreme Court decision in Basel Wind Solution Private Limited versus G Power Conversion India Private Limited in 2021, wherein the apex court permitted Indian parties to choose foreign seats, even if the subject matter of their contracts and counterparties is entirely situated within India. Further, option 2 also provides no clarity as to the choice of seat in case of international commercial arbitration. And finally, we found that the draft bill is silent on whether parties are free to agree on choice of seat in case of international commercial arbitration. So, this is all the new changes would be made as provided under the draft bill in regards to Arbitration and Conciliation Amendment Bill 2024, which was placed in the Parliament in February 2024 to bring out these important changes. As regards that already we have discussed, it emphasizes those particular changes, and that exactly in regards to the promoting institutional arbitration in India, and so also in regards to minimize court intervention in arbitration proceedings in relation to interim awards, and as also provided under Section 9 of the Arbitration and Conciliation Act of 1996 by amending Section 9 and by inserting a new section, Section 9A, and also the provision is regarding emergency arbitration also inserting under Section 9A and appointment of arbitrators, another change which would be brought under the draft bill once it would be enacted as an act under Section 11. That is also another attempt under the draft bill. So also the very important, the last one that was also placed in the draft bill is regarding the very place of arbitration, which is explicitly provided under Section 20 of the Arbitration and Conciliation Act of 1996, though these are the proposed amendments by the Government of India in regards to the very draft bill on Arbitration and Conciliation Amendment Bill of 2024. So, in this lecture, almost we have completed every aspect and the very aim and target of the Amendment Bill of 2024, and the very draft bill is known as Draft Arbitration and Conciliation Amendment Bill of 2024.